Hello, my name is attorney Jason Lile, and I am the Oklahoma Will and Trust.com attorney in northeastern Oklahoma here. And I would like to talk to you a little bit about a question I get. When I'm doing estate planning for people, people often come to me for a trust. I do a lot of trusts, I draw them up, I have experience at litigating them. So that part we've got. The second thing, though, that people ask me often is, do I still need a power of attorney? Oftentimes they'll come with me and they have an existing power of attorney, or they want to know if they need one drawn up as well, because obviously there's some extra expense through an attorney's office to draw up a power of attorney. The simple and quickest answer is absolutely, and I'll tell you why. You also need a power of attorney because trusts have a limitation we discussed in a previous video, basically that they only give the successor trustee power over the things listed in the trust, okay? We can and do pour over wills, as I've described earlier, to make sure that if you end up in probate court, the probate judge is aware that you intended to put all of your things in the trust, okay? But a power of attorney is general. We call it a general power of attorney for a reason, and that means that that person literally steps in your shoes legally when that power of attorney springs, whether it's immediately, if that's what you put in the power of attorney, or if it's contingent upon something like your incapacity, mental incapacity or physical incapacity. When the power of attorney springs, and it's effective, that person with power of attorney over you and or your things has power over everything immediately. Now, there is a section in a power of attorney that lists the specific powers, but they are typically not, except in a limited power of attorney, they are not exhaustive. So that makes sure that if you forgot to write something on the schedule in your trust, if it's not funded with everything that's titleable in your name, then the general durable power of attorney gives the person the power to do any of your business, conduct any of your business within reason. And keep in mind that a successor trustee and a power of attorney is what we call a fiduciary duty, which means that person has to act in the best interest of your estate, your trust, you as a person, not their own. So you are protected by the laws that govern fiduciary relationships. At any rate, you do need a power of attorney. A good attorney should be able to advise you how all of these tools work together to protect you and your estate and your needs. And if you have any questions about this or any other estate planning matters, please look me up at oklahomawillandtrust.com or call us at 918-876-4500 and ask for attorney Jason Lile. Thank you.